Item 1 for motion.
Request your lordship, it is with respect to item 13. Well, on the last occasion, the state took time to find a reply. The person is in detention, and we fear that the item might not reach. So either may I seek favor to pass an order?
Item?
Item 13.
13, third. Lordship, can it be on Monday, Lordship?
Earlier occasion,
I will get the instruction, Lordship. If it will fix on Monday, Lordship, nothing will happen.
on the earlier occasion, the state took time, my lords, and my lords,
Yes, lordship.
your lordship were considering the release. She's 57-year-old lady.
In 2
suffering
days,
from
nothing will happen,
ailments.
Lordship.
Okay, one day will not have an effect. Monday.
Yes, Lordship.
Okay, both sides are represented. Mr. G. Sharma, Learned Standing Counsel for FT, submits that he would try to obtain necessary instructions in the matter. And prays that the matter be listed on 2/9/2024. This prayer is allowed. List on 2/9/2024. You make a prayer, we'll upgrade and take it out.
Item 1.
Lordship. My lord, this is a old case. In the year 2013, my husband Hayat Ali was killed by police by indiscriminate firing. And in this regard, my lord, I have filed an FIR that was filed on 27/12/2013, page 56, my lord.
You see, but ultimately in this case, final report was submitted.
Yes.
After final report, there is a so far as the case instituted on a FIR is concerned, the only remedy available to you is to file another petition and then move ahead.
That is already done, but there's simultaneously, my lord, here are, my lord, 3 prayers we have made. First one is this, that the investigation should be made by a high-ranking police officer.
No, after you see, when there is an FIR, then there is a process to go ahead. That is one. We cannot have a parallel inquiry, and also an RRG petition to be examined. That is one. The second part is that in this case, there is a plea taken in the FIR as to what has happened, why firing was made. So if that be so, then your only remedy would be to have to move the government and have the compensation as per the notification.
We have 3 prayers. The first prayer was that. Now that may be also ordered because Naraji petition has been already filed before the learned trial court at Kokrajhar.
Is it
Second
available here?
thing, my lord,
Is your Naraji petition available here?
no, Naraji petition we have not annexed here.
Okay.
But second prayer is this, the entire matter should be inquired into by the learned district and session judge Kokrajhar. Because here police personnel are the accused persons. They have started this indiscriminate firing. Instead of arresting 3 suspected NDFB persons, and the persons who were protesting for killing their children, etc., earlier occasion, police, they tried to protect them. So that's why mob became irritated. Now, if the police would have started that, there's 3 persons, then everything would have ended there. But instead of that, police started indiscriminate firing, and as a result of this, several persons of various communities were injured, including my husband Hayat Ali. And he were brought to hospital where he was declared as dead. Now, third prayer is compensation. So here are 3.
Where is your application before the government for compensation? You are making a statement that you had moved from pillar to post for compensation. Where is your application for compensation?
That is not here, madam. Actually, my lord, they even did not accept my FIR. Then I was compelled to move the SP Kokrajhar, who forwarded the case to the OC, and then only case was registered. In this process, there was some delay. Now the case has come into end because all the accused persons are either police or higher officer of the police. After all are police. So police has investigated the case of police. So we have no faith on that. That's why, my lord, we have prayed that a high-level inquiry through district and session judge Kokrajhar should be even. It is the normal practice, man. It is.
The difficulty is that under the new BNSS, we have seen 193, I think 193. You see the provision of 193. I think it is 193 because
Yes.
I won't remember.
Yeah. Yes, my lord, we have said section 193 of BNSS mandates that a police report must also include details of the sequence of the custody in case of electronic device.
No,
The
no,
section-
then it's wrong. 196.
Yes, well, 196 of Bharatiya. And after 11 years, this final report has been after 11 years.
No, that's okay. But now we are in the regime of a new BNSS. Look at 196.
196
It is it is by
prohibits
magistrate.
promoting enmity between groups
It
based
is
on.
by magistrate.
Melo?
196
Yes. Bharatiya Nyaya Sanhita.
2. 196 2. While such person who in the custody of police or other authorized persons so under Sanhita, in addition to the inquiry investigation by the police, an inquiry shall be held by the magistrate within whose local jurisdiction the offence has been committed. So now the inquiry can only be ordered through a magistrate.
My lord, the DSP is the accused in this case.
But
And
that is the law, we can't help it. Unless,
No, the DSP is not the accused.
no, DSP, because
No, DSP is not the.
no, DSP is in that sense, he is the IO of the case and he filed the final report. In that sense, that person may kindly see, it is here. Kindly see page 76. জীবন দাস APS উপ আরক্ষী অধীক্ষক চিরাং জেলা
Right, he is the IO.
IO, yes.
He is the IO.
IO come DSP.
Well, but page 56 is the FIR. Page 56 is the FIR filed by the petitioner. And in the FIR, they have named 3 officers. I have seen Malad, accused number 1, Hitendranath Roy. He is the OC of that police station. The other 2 are officers. And Malad, the case was investigated by DSP. The prayer made in the writ petition is that here, in the writ petition, if Lordship comes to the prayer, Malad, they have prayed that the investigation should be done by a high-level police officer. That is the prayer, Malad. Investigation was done by DSP, Malad. At page 11, they have made a prayer, Malad.
Please go on.
They have prayed that
No. You see, we come back to that same query we were putting to Mr. Mahmood.
Lordship,
You see, when there is a death by way of a police firing,
police
then
firing.
the under the old law, that the inquiry would have to be made by the district judge.
Lordship.
Now
Now it is changed.
it is changed.
Lordship.
So in this case, was there any such inquiry
Well,
on the police firing?
In fact, page 23, Lordship will find the FIR has been registered. Or into the incident, FIR has been registered and investigated and charge sheet has been filed. Page 23 is the FIR.
23.
Page 23.
It is filed by police
In the petition.
against us.
Mala, into the incident, there was an FIR into the incident. Ultimately, this is the same incident or happened on 3/12/2013 at 1:45 PM. Into that incident, Malad, an FIR was lodged. And it was investigated and charge sheet has been filed. The trial is going on. Page 30 is the charge sheet. Malad.
No. You see, come to page 25.
Malad.
This is not with regard to 302. This is with regard to 307. That means assault on the police. But what happened to the inquiry for the person who is dead? This is 353, 326, 307.
Lodge.
So attempt to murder.
Lodge.
But what has happened to the there is no denial that there is a dead body.
There is a dead body.
So corpus delicti is available.
Therefore, Malad, the case was registered. At page 55, Lodge has seen, Malad.
So
At the
registered
same-
matter,
at the same
11
time-
years.
At the same time,
After 11 years, FR filed.
Just a moment.
at the same time, that FIR was lost and it was registered, Malad. The SP has forwarded it to the OC and the circle inspector Kajigao for information, and he will take up the case. He was directed to take up the case, Malad, the circle inspector. And-
Where was that?
Page 55, Malad.
No, the report is page.
Uh,
Yeah, FR.
FR is at page, Malad, 59. 59 is the type copy.
I know one moment, one important thing is here.
We'll call for that case diary of this case, Kajigao PS case number
Kajigao.
1 of 24.
Logic. This may not be one of 24, Malad.
74 lakh.
1 of 14, my lord. 1-4.
1 of 14,
They have wrongly typed, Lord. Kajigaon PS case 1 of 2014.
14. Mr. M.U. Mahmood, learned counsel for the petitioner, and Mr. D. Nath, learned senior government advocate, appearing for the respondents. You are appearing for all?
Lord, some private persons are there, Lord.
Private,
Except 1 to
I think they're
1
police
to 5
personnel.
I'm appearing.
I think 9 and all are police personnel.
all are police persons.
They are in their personal capacity, my lord, because they said that they have some malafide intention.
1 to 5.
Went to 5, 7 also, my lord.
7 I can, my lord. In charge Rupsi
So
outpost.
1 to
If
5
it is
and
there, I
7.
can.
1 to 5 and 7.
Lord.
Uh, Before issuance of notice in the matter, the court is inclined to examine the case diary of Kajigaon PS case number 1 of 2024 under section 279/338/304 IPC, read with section 27 of the Arms Act, in which final form has been submitted final form number 7 of 2024 dated 31/1/2024 was submitted before the where
Learned CJM Kopraja.
Chief Judicial Magistrate Kokrajhar. As well as the copy of protest petition, if any, filed by the petitioner. Next one. Registry shall requisition a scanned copy of the case diary as well as the protest petition, if any, filed by the petitioner against final form number 7 of 2024 dated 31/1/2024. The registry shall send the requisition by email with liberty to the Chief Judicial Magistrate. Which place?
Kopraja.
Pokrajar.
Kokrajhar. Transmit the scanned copy of the case diary and protest petition, if any, by email for being placed before the court. Next, list on. List on 209/2024.
Lord, it is Kajigaon PS 1 of 2014.
Oh, 2014. 2014. Please give an extra copy.
Lord, I'll
Like to calculate. Just before that, requisite extra copies of the petition we furnished to the learned senior government advocate to enable him to obtain instructions.
order.
Item 2.
Please, your lord.
Yes.
My lord, petitioner before your lordship is a retired employee of Indian Air Force, my lord. He was
Indian
bo-
Air Force.
Yes, my lord. He was born in the year 1958, my lord. At the age of when he was 6 years old, my lord, he lost his father, my lord. Then your lordship will find page 17, my lord.
What is the best document you have? Link yourself to your projected parents or grandparents.
My lord, the petitioner himself was in India prior to 1966, my lord. This is the school certificate, my lord.
Where is that?
Page 17, my lord.
Did the headmaster of the school come and depose in your favor?
Yes, my lord. Then, my lord, your
Where
lordship,
where is his evidence of the headmaster?
page type copy, my lord, page 16. Page 69, my lord.
69.
Yes.
Okay. Let me say AMHR Chaudhary and counsel for the petitioner. Is A. Verma and standing counsel for the FT representing respondent number 2, 4, 2 and 4. Ms. P. Barber and standing counsel for the respondent number 5. And Mr. H.K. Hazarika Leonard, government advocate representing respondent number 3. Was CGC, nobody is there. Whose name we can record? Whose name we can record? L. Devi. Ms. L. Devi, Leonard Council appearing on behalf of Mr. R.K.D. Chaudhary, standing counsel for, DSGI for respondent number 1 and 6. By filing this representation in Article 226 of the Constitution of India, the opinion dated 23/1/2023, as this also page 1 and 2 is assailed in this assail. Next paragraph. Issue notice returnable in 4 weeks. Requisite extra copies of the representation be served on the learned DSGI, State and Departmental Council within 2 days, 2 working days. Next, let the records of so and so be requisitioned. Next, subject to steps being taken as indicated above. Bill 5,000 with to the satisfaction of
My lord, Sunitpur, my lord. Sunitpur.
SP border,
SP.
Sunitpur. With those conditions. So the learned counsel for the petitioner shall inform the court on the next date if the petitioner has taken bail. expired. This is the matter on receipt of the records of the tribunal.
Deeply.
Item 3,
Me, please, allow.
Yes,
My lord, here in this case, my lord,
just a moment.
the decision was given on contest. And petitioner's father is voter in 1966, 70 also, in 85 also, in 89, 93. My lord, one of the brother who
How
is
do you
voter,
connect yourself with your projected parent?
my lord, one of my brother who is voter with my parents are examined. And he claims that the petitioner is his sister.
Where is that voter list with your brother?
My lord, brother's voter list, my lord, at page 35. Mother's name is Sabjan Bibi. And Jamaluddin is the OPW2, my lord. He was examined. My lord, here and there some variation of name is there that has been also explained in the WS and evidence.
Johuruddin is your father's name.
Father's name, my lord. Zohuruddin, in some documents also Zohur Ali, my lord. That is the, my lord, point the Learned Tribunal has taken up, my lord. But grandfather's name is Ismat. Mother's name is Sabjan Bibi.
That is matching.
They maintain, my lord.
But why the delay in approaching this court?
My lord.
Why?
My lord, old person, my lord, unable to collect the, my lord, my lord, expenditure. That is the main reason, my lord. Delay, my lord. Judgment is of 23, yeah, August 23. I have stated in paragraph 19, my lord.
With plot of land held by you, you are still not having money.
My lord, father was the, my lord, look, that is also, my lord, they are unable to bear the cost, my lord. There they have, they are also unknown that there are some lawyers who are doing, my lord, pro bono. That information is not available. Therefore, they have
Not available.
approached me.
Good. So your reputation has not traveled far and to the interior places.
No, my lord.
Still. Yes. Notice call for the records, Bill, Mr. A.R. Siddhar, for the petitioner. Opinion dated 31/8/2023, page 2. Bill to the satisfaction of
Section, my lord, Nagaon, SP Nagaon, my lord.
SP Border Nagaon.
My lord,
Respondent counsels will be Varma, Mr. Ms. P. Barwa, Mr. H. E. Hazarika, and A.I. Ali. Yes,
my lord. Minimum time, my lord, not less than 10, my lord.
10 days.
2 weeks time is better, my lord. 14 days time is better, my lord. 7 days.
Nagaon. You said Nagaon.
Nagaon, my lord. So, well, 10 days is
10 days,
work
within 10 days. Okay.
When the court gives you a privilege, you should grab it. Instead of praying for 10 days, you should have prayed for 48 hours
Deep level.
before the court changes mind.
Yes, my lord.
Item 4.
May I please, Lord?
Yes, Mr. Latkar.
Petitioner's grandparents' family admittedly came to India in 1964. So, at page 82, there is a refugee identity card.
Page
82,
80,
82, 882.
82.
Yes. It is the
What is his name? Grandfather's name?
father's name is Samar Chandra Roy. He was 10 years old when the Shailesh Chandra Roy is the grandfather. Sadhana Rani Roy is the grandmother. Samar Chandra Roy is father. The petition. And the date of migration is given 7/11/1964. And his
How did the tribunal deal with this document? This is exhibit number?
My lord, tribunal basically held that this Samar Chandra Roy is not the father of the petitioner.
Is not the father of the petitioner.
Is not the father of the petitioner.
It shows that part of the finding.
So
You
page
aren't-
124.
Your name is Sajal Roy.
Yeah, my name is Sajal Roy.
Please tell again, your father's name is?
Samar Roy, Samar Chandra Roy. And in voter list, it appeared Samar Roy. Shailesh Roy, my grandfather's
No,
name.
there is another document where your father's name is different.
No, my lord, my father's name always appeared as
No,
Samar
there
Roy or
is-
Samar Chandra Roy, but my grandfather's name in one document, this at page 123.
Yes.
Dear Lord's
Come to page 88.
88.
Samar Roy. Father's name is Radhakanta Roy.
Yes.
Who is this Samar Roy?
Samar Roy is my father,
Is your brother.
my father. And my
Father's name is Radhakanta Roy here.
my grandfather's name, paternal grandfather's name is Shailesh Chandra Roy, Shailesh Roy. And this is a mistake which is clarified in the WS that Radhakanta Roy is actually my maternal grandfather's name. This is clarified in the WS itself. And there are other.
What is the name of your wife?
No, petitioner Sajal Roy is unmarried petitioner. My mother's name is Rita Roy, or Rita Rani Roy.
Thank you. Where is the finding of the tribunal? Tribunal
124,
opinion.
my lord, page.
Opinion of tribunal.
Yes, this is the relevant part, the last conclusive part, 123. So there is some discrepancy in voter lists of 1997. Based on that, the tribunal held that my father is not
Where is, which page?
124.
124. Pardon me?
122. On careful perusal of the aforesaid electoral rolls, the following queries have been propped up requiring explanation from the election officer, Silchar, thus giving rise.
122.
122, Lordship may come to 1, 2, 3, 4, fifth paragraph on careful.
Perusal of the
Yes,
aforesaid electoral,
Lordship.
yes.
On careful perusal of the aforesaid electoral rolls, the following queries have been cropped up requiring explanation from the election officer, Silchar, thus giving rise to letter so and so.
No, but then the question would be wrong. This question would be wrong.
Yes,
You
Lordship.
see, come to page 101. If his wife's name is Rita Rani, sorry, mother's name,
Yes.
Rita Rani, then father's, paternal grandfather's name is Radhakanta Roy.
Yes, maternal grandfather.
His linkage has to come from his father, not from the maternal.
No. His father's is also there.
Yes, Lordship.
His father's document is also there.
Yes, 82, page
Page
83, the vernacular. I mean, the
third
copy of the
paragraph
original.
from the bottom.
Huh?
Page 122, third paragraph from the bottom.
Mm.
Yes.
In exhibit
On
one,
what
my lord.
basis? These are queries raised. As to on what basis?
Hmm.
Page 122, the just immediately after that, on careful perusal of next paragraph.
Right.
Other of the elector is changed from Radhakanta to Shailesh Roy. To the- As we put it over, then a completely different thing. Some explanation somewhere. But in this, the name of the proceedings father is not reflected in page 100.
This relates to the maternal grandfather's family. Page 83 is the paternal grandfather's family. Then in page 83, there is the Shamar Chandra Roy at CL number 3. Radhakanta Roy is the maternal grandfather.
Okay. So there is a confusion. What is the confusion?
In voter list of 1997, the name of the Shailesh Chandra's father is something else, Shyam Sundar Roy. That is explained in the WS that it was mistakenly entered and it was
In
not
WS, you
correct.
have explained that.
Yes.
Where is that? Your WS?
WS starts from at page 59.
59.
Yes, ma'am.
Page 60 question. Verification of this, Mr. Pulaskar for the petitioner. Ms. Verma. For the FT, Mr. R. Tarugdar, government advocate, and Mr. H. Kuli, appearing on Mr. Council, appearing on behalf of AI Ali, standing for the Election Commission of India. And CGC is M. Adhikari. FT case number is at page 2.
Case number 201.
Bail to the satisfaction of Superintendent of Police, Border Kachar. It is within 10 days. Yes, I can see, same on the
Within 10 days. Publish.
Item 5.
My lord.
Directory doesn't. Directory doesn't.
Ms. Verma, there should be some system in the bar where we can understand if some learned lawyer has expired. Now we are unable to what do you call recall her face. Therefore, there is a disconnect.
Yes, even Lordship is talking about today's reference. Even I have not been able to place Lordship.
There must be some way to, because if we are a part of it, and if somebody expires, if the face can be recollected, it is at least we can express
Yes, Lordship.
some
Even I saw it on Facebook. I asked some people, but I could not connect with
in LinkedIn, there are two photographs. Two ladies are coming with the same name.
Heard she was unwell for quite a long time.
No, maybe, but without looking at the face,
Yes, Lord.
it becomes what do you call the expression of grief becomes very impersonal.
I understand, Lordship.
Yes.
My lord, father's name, my lord, page number 40.
40.
1965 voter list,
This Pulan Sheikh. Also page 42, 1970 voter list, which is more clear, my lord, because here the vernacular is not very clear. So you could not mention the name of the village, which is Bilasipara.
41, you can't even read.
My lord.
Page 41, you can't even read.
Yeah, page 41, this page, my lord, it is not legible. The names are legible, but the village name, that's why, my lord, next page, my lord, page 42, 1970 voter list. This is, my lord, legible, my lord.
65 Pulan Sheikh.
Pulan Sheikh, my lord. That is legible, my lord. But the upper portion is not legible. So,
10/10/2017. This is 1970.
my lord, 1970, Pulan Sheikh, my lord.
Yeah.
And my linkage, my lord, Gavura certificate, my lord.
No, but somewhere your mother's name is different.
Mother name, my lord, it's written in different forms, Surutun, Durutun, but these are same people. My lord.
65 voters list, lordship, the first discrepancy starts with the age. The father's 45 and then 70. 70, it's 50. 65 to 70.
Surutun is the exact name, my lord. But there are variations, my lord.
Ulan also Palan. Number of subsequent particles, no? DW3.
Govardhan. Yes, Bilaspur.
नहीं कुछ भी समझ में नहीं आ रहा कुछ which paragraph Downward deposition bottom. Downward deposition is yeah. Eighty-five last voters, it's 65, 70, 85.
Mr. Talukdar, strange things are happening. Come to page 50. If you have a copy. You have seen page 50. The original is at, the photocopy is at page 51.
Yes, sir.
Correct.
Yes.
Land is a Exonia land, and
Yes.
there is a Patadar's name.
Yes, Lord. Two Pattadas. Palan Sheikh and Akus Ali.
If it's Exonia, it will be a government land.
Lordship.
What's happening here?
It must be government land, Lordship.
Has to be Exonia. Is there a,
Annual.
what's happening? There are your own people. People who are maintaining land records are your own people. Your employees, trusted employees. What is any other document to link with your father?
My lord, Gaubura certificate and the brother whose name appeared with the mother also appeared as DW2 and the issuing authority of Gaubura certificate as DW3, my lord. So these three links.
Where is the Gaubura certificate?
My lord, page number 62.
Lordship, may kindly come to the deposition of the Gaubura at page 81, Lordship.
Where is that?
Page 81, Annex 18.
81. Yes.
Lordship, I have come to depose in order to verify the certificate issued by me to Firoja Khatun. I know the second party. I have not seen the parents of the second party as they died very early. The second party's father's name is Palan Sheikh. I don't know the mother's name of the second party. I have written the second party's mother's name as told by her. The second party's father's name is recorded in the voters list of 1965. The second party was born in the village of Bilashipara. She was married to the village of Kaimari with Sumuj Ali. Exhibit M is the certificate issued by me and is my signature. To the tribunal, I don't remember since when I was appointed as the Gaubura. I don't know when the second party was born. The brother of the second party has told me that she was born in Bilashipura. I don't know personally where the second party was born. I have mentioned the name of the father according to the voters list. I didn't bring any records. I didn't conduct any verification to ascertain as to whether Palan Sheikh is the father or not. He has deposed, he has come, but he has not brought any record.
No. You see, Mr. Kuli is sitting behind. I asked his name. Every day I ask his name. The last 4 weeks I am taking up this bench and every day I ask his name. So therefore, the reason for not knowing the name may be plenty.
Yes, Lordship, but he did not bring any records also when he
No,
deposed.
correct. There's no record. You see, number one, you are asking question which somebody cannot answer.
Yes, sir.
Now the tribunal asks this man to bring record. Now, under the, for the purpose of Gangura, under the executive instructions, do you have any mandate to a Gangura to maintain it? So if he is not maintaining it,
Then that document cannot be proved because Rupajan Begum says.
no, this
whichever
oral evidence still
certificate-
comes. Oral evidence still remains.
Oral evidence has to be supported by material facts, Lordship. It cannot be, oral evidence cannot be just taken
No,
at face
You
value.
see, the government does not want the, this Ganguras to maintain records. Otherwise, they would have given a executive instruction. You maintain a record.
But most of the times they are supposed to come with records and it has to be verified at two stages, Lordship.
No,
One the contents and one by the author.
no, you
look
see,
into the instructions, I think there is something there. Revenue regulation. Look into the instruction, there is some record to be maintained.
it was personal law. It was.
Mhm.
It was split personal. No, This is true.
The report, correction, revision, the reports, and then it gets away. Go to the review, the factors, necessary.
Maybe, sir, it will be.
Made by which?
For example.
When I was collecting. Really, it was coming for you, and that was a really important way to do it. There is no way to. More than I was going to take it from the state. But the idea is to think about it, even when it's what the information will be available.
Yes. Formula.
It is starting to relate. You have to report. You can do, review.
Lordship, may I place a judgment, Lordship, on exactly this point? This is in one of the matters Justice Mia and Rumi Fukan had passed this order. It is tried that documentary evidence would have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. proof of document is one thing and proof of contents is another. Not only the document would have to be proved, but its contents would also have to be proved. That apart, the truthfulness of the contents of the document would also have to be established from the record. A document or the contents of the document cannot be proved on the basis of personal knowledge. And this is regarding the Gaubura certificate. Further, it says when the petitioner was not a resident of the village Kukurapar on the date when the Gaubura had issued the certificate, Gaubura could have issued the certificate only on the basis of record maintained in the office, not on documents produced before him, Lordship. There's a number of judgments to this effect, Lordship, and which have been followed by most of the benches, Lordship. Just bringing some records, Lordship, a voters list. I think 2 days back also I had placed it before this court, bringing the voters list, an extract copy of the voters list and asking the Gaubura to issue a certificate. That does not, that is not within his knowledge. People move, they keep shift from village to village, and at the time of proceedings or when they have to. Will- Yes, Lordship. But he himself has stated, and he is not the author of the certificate also, Lordship. He has not issued that certificate. If Lordship comes to page 37, Lordship may kindly come to page 37. The second paragraph, proceedee second party exhibited Gaubura certificate of village so and so, but the proceedee second party did not prove the certificate by author of the certificate, as much reliance cannot be put into it. Put on it.
That is a different one.
Which one?
Another certificate was issued. So this is page number 36.
36 is the,
Exhibit M.
yes,
So this
exhibit
Gaubura
M.
appeared.
Yeah.
This Gaubura appeared.
This Gaubura appeared on page 36, paragraph 3,
That's what I'm
Lordship.
relying on.
I'm reading that also.
Yes,
That is,
Yes.
Lordship, that's, may I just read the opinion, Lordship? Second party exhibited Gaubura certificate as exhibit M, and to prove the certificate, proceedee second party examined the Gaubura of village Bilashipara. DW3 in his examination in chief stated that he knows proceedee, but he does not know the parents of the proceedee, and they expired many years ago. He further stated that proceedee father's name is Palan Sheikh. He does not know the proceedee's party's mother's name, and as per proceedee's version, he wrote the mother's name of the proceedee. In the certificate, he further stated that proceedee's party, second party's father cast vote in the year 1965, and proceedee was born at Bilashipara and so and so. DW3 on being questioned by the tribunal deposed that he cannot remember when he was appointed as Gaubura. He deposed that proceedee's second party's brother told him that proceedee was born at Bilashipara and he has no knowledge about the place where the proceedee was born. He further deposed that he did not brought any record and that apart to ascertain the father's name of the proceedee, he did not make any verification. The only certificate on which,
How does it make the evidence disbelievable? Because you see, there are many people I know personally, my very good friends. But maybe I would not know the name of their mother.
yes, Lordship.
It's quite possible. Now,
But Lordship-
that's one part. Now, you see, when I tell you I was born in Guwahati, you can tell some people that he was born in Guwahati. But if I ask you what is the place where I was born, then the answer would be obviously no, I did not see that. So that's only a hearsay statement that he may have been born at a place A or B. But you may know a place of birth of a person. But if I ask you that where actually he was born, it's a very difficult question. And it's a trick question. I was born in Guwahati Medical College and Hospital. Which room? I never asked my parents. The certificate does not say. The birth certificate does not give the exact, what you call the
Details of where the
details of
person-
where
yes, Lordship.
actually it was born. So it's a trick question. You ask a question and then you can give any answer you want.
Here, the matter is different, lordship. In common, for common people, it's so, but here their citizenship is under doubt. It is, the burden is on them to prove it, lordship, that their existence was here, and the Gambura has to prove it.
No,
It
is
is
there any,
more
see, I
heavy and
tried,
difficult for them.
no, I tried my best to make a search. What is a contemporaneous document? Is there any finding? Anywhere, any revenue records, anything which prescribes what is a contemporaneous
Will
record?
give us some time, we will look into it and get back, lordship.
Because for that, I think best person would be to have an assistance of the standing counsel for the revenue department. So they will be more acquainted with the functioning of the Gambura.
Gambura. Revenue or panchayat? Panchayat,
Panchayat,
revenue, Gambura.
it's only revenue. Panchayat and under the Panchayat Act, the role of Gambura, I did not find anywhere. It's subject to correction, I can't be so certain. But in Panchayat Act,
No, there's nothing.
Certificate, dipolo, no.
So the revenue.
Lordship, there was a debate sometime back in one of the courts whether Gambura even has the power to issue a certificate or not. This question had come up during Justice Bujur Borua's time also, and revenue was asked on that.
See, anybody can issue a certificate. I mean, there is no
Bar.
negative law which says that bearing these people, nobody can issue a certificate.
you see, let me tell you, you see, there may be many institutions of repute. For example, maybe IIT or maybe medical college, where they say you bring a character certificate. Correct. Now, there will be a debate as to what is a
Character certificate.
what is the characteristics of a character. Correct. For me, since I am a veg, maybe I would not like a person who is having a non-veg. But does it reflect the character of a person? He may be a very, very good person like you. But can I? So these things are, you see, unless these are codified and says that who can give a character certificate.
Therefore, the contents. Therefore, the contents.
Contents.
My cousin sister wanted an admission in class 3 in a school where they required a certificate of reference. Now in class 3. So therefore I had to step in, I had to give a character certificate and a recommendation certificate. But you see, to have a recommendation at class 3 is something which is very questionable.
Yes.
Why do you need a recommendation? When there's a child education policy, compulsory education, there you want a reference. Why? Have it,
We will need to revisit Sabananda Sonowal once more to see lordship about the written statement and documents. I will also refresh myself and come back again on Monday.
At this
lordship.
stage, I'm only requesting for a bail. Because the police is searching for her. Interim at this stage, and later this may be examined.
but you have been able, from 2020, you have been able to dodge.
But now the
2020, now we are in 2024.
now the police is, this is not at home, my lord. Old lady, my lord. Humble request, my lord. Maybe protected.
2020, because the explanation part did not find it very convincing.
Your lordship is, I bow before your lordship. But now that police is searching, old lady, my lord, maybe protected, my lord.
What is their age now?
See that 55.
55 is old.
In village, my lord, people gets old very early, my lord.
55, my lord.
Very good.
55 is very old in.
We had heard the arguments otherwise.
So there was a time when the life expectancy was 32. Now it is more than 67. So the better the health facilities, the younger.
I have seen the argument of a very seasoned lawyer when he was 91, and he was fantastic.
Probably he was in urban area, my lord.
Bilasipur is an urban area, by the way. It's a, it's
This
the,
is Bilasipara in Barpeta. This is a village. This is not that Bilasipara.
oh, achha.
Yes, my lord. That is in Bongaigaon, my lord. This is a village Bilasipara.
In case hearing the matter.
We are calling for the records before issuance of notice in this matter. So A.W. Aman, counsel for the petitioner. Ms. A. Verma, Leonard, standing counsel for the FT. Ms. P. Barwa, Leonard, standing counsel for the Election Commission of India, and Mr. R. K. Talukdar, Leonard, government advocate.
Respondent number 4.
For respondent 4. The court is inclined to examine the records of the proceeding against the petitioner before issuance of notice. Accordingly, the registry shall requisition the records of FT case number 59 of 2018. Disposed of by opinion dated 29/12/2020 by the Foreigners Tribunal number 8th Barpeta in FT case number 59 of 2018. Arising out of IMDT case number 1162 of 2004. It's page 2. huh? Requisite extra copies of the writ petition be served on the learned CGC, State and Departmental Council within 2 working days. Next one. Subject to steps being taken. Run bill 5,000 to the satisfaction of Superintendent of Police Border,
Barpeta.
Barpeta. The next date, the learned counsel for the petitioner shall apprise the court as to whether the petitioner has taken bail. Give 10 days time to take bail. Next one. Just after 4 weeks, awaiting receipt of the trial court records of the tribunal. Ms. Verma, Mr. Sharma, please try to contact the counsel for revenue. I think Mr. Hendik
Yes.
is one, and then
Yes.
the court query about the scope of the Gambra to issue a certificate.
Yes.
Perhaps on Monday or Tuesday, whenever we have time, we'll hear that.
Yes.
that issue.
I'm grateful, man.
Item 6 for admission.
May I plead your lordship, as per last order, my lord, pass an order for the petitioners appear before this SP, my lord, but I am trying several times, my lord, but not to communicate her, my lord,
You could not communicate.
my lord.
also is the representative on the prayer made by Ms. And Wazira counsel for the petitioner. List after 2 weeks to enable her to obtain instructions. In terms of order dated 24/7/2024.
Item 7.
May I please out? My lord. Kindly print the judgment is relevant portion is 90, my lord. Although all the documents submitted by the petitioner is her father's name enrolled in the voter list of 1966, 1970, 1977. All the documents disbelieved by the tribunal. Page 90.
Where is the voters list? First voters list
1966, page 39.
is 39. Page 39.
Yes, my lord.
Okay, next.
Near Sagar Ali,
1970.
1970. Next, 41. Her elder brother's name also appeared there in 1970.
Where is what is his name?
Omar Kazi,
More Kashi.
1970 voter list. Then, my lord, petitioner's name enrolled in the voter list of 1989, that is page 45.
Just a minute. Where is the written statement?
WS is
33.
33.
But in your written statement, you don't introduce your uncle. Now,
No,
turn
I
his
never
uncle as a
said,
peer.
I never said that Zuhur Ali is my, Zuhur Ali is my uncle. I never said. Notice served on my name and my husband's name, Kubad Ali. My father's name Sagar Ali, not Johur Ali. I don't know where from they collect Johur Ali, name of the Johur Ali.
Who are the witnesses who appeared for you?
My lord.
How many witnesses you examined?
DW 2, 3, 4, 5.
2, 3, 4, 5. Where are those depositions?
DW 2 is my elder brother.
Which page? Deposition?
Deposition. DW 2 71.
71.
Omar Kazi. Uh, 76 is deposition. DW 2 76.
You see, you have destroyed your own case. Deposition of your brother is at page 71.
71.
Correct.
Correct.
Now you look at the statement made at wrote paragraph 13, page 73. Look at his statement.
Somewhere Sonabanu Bibi, somewhere.
No, he is Omar Kazi. Now he is saying on oath that his name is Sona Bhanu Bibi.
Yes.
That is on oath.
Yes, madam.
Then, so DW goes.
Sonaban Bibi and Sonaban Nessa.
He came as your brother and he became you. The evidence goes. Now, what is another evidence?
He deposed that, but in some of the voter list, my name has been erroneously recorded Sonaban Bibi.
But you know, Ms. Bama,
Yes, Lord.
your GP was more better. Come to the cross-examination at page 75.
Yes, Lord. Procedure is my
At his
age.
question, now the answer in para 3 is proceedee. The second paragraph, proceedee is Sonabha Nessa, married so and so. He is in the cross-examination clarified.
Your brother did not vote in 77.
That time, yes, but in the voter list with his father, his name is not there.
Then
Maybe that time he's separated.
Any voter list of you along with your brother?
No,
brother, father,
no. I have casted my vote after my marriage.
But there's a difference of name, Sagar Ali Sheikh, Sagar Ali. The only a voter list cannot be a linked document.
No, linkage panchayat certificate also.
Panchayat certificate, he says they're only for the NRC.
Yes, madam.
That is the cross examination, is only for NRC. So that goes, doesn't help you. If that goes, you are disconnected with your projected father.
not a single document. Not a single document.
Only link certificate, only panchayat certificate, not.
And
And,
your
that is-
brother also, after 2 years, he disappeared.
Hello?
After 2 years,
Yes.
1970,
Yes.
I think 68 and 70, for next 10 years or 18 years, he was not available.
No, up 66, 70,
Then
then 77. Then 77.
where is 77?
77 is space. Tagore Ali. Page 43.
No, brother.
Brother.
Your brother,
Brother only 70.
Then
After 70, he separated from the family.
Lordship, there are 10 siblings. The name of only one brother is projecting. Other family members, at least the brothers,
no explanation.
no explanation. There is no voters list to link, nothing, Lordship. In her
No,
WH, she says,
after my marriage,
After your marriage, you have shifted to that village with your husband, your names, everything is
Yes.
there. But the brother you are projecting, he appears for only once. Then he gets separated.
other voter,
Then the other brothers and sisters are there. None of them are there.
if the court,
there's no common, what you call, voters list where all the brothers and sisters name or at least few
Your
of them are
existence
together.
in the parental village is not even there.
no, after my marriage, no better voter list I have enclosed my law.
No, you have made statement that after your marriage, your names appear along with your
Yes.
husband and family members,
yes,
etc.
yes.
But before that,
Before that, no voter list with my family.
but no voter ID is no reference to, except for your
Oh.
parents and one brother. How do you establish the link?
No, my younger brother, elder brother, no. After my marriage,
No, you.
My
must have-
second
you
brother
see,
was born.
You must have brothers and sisters in your parental family.
Yes.
There's not a single voters list to show that there's a family.
okay. Then I will be allowed some time. In the meantime, I will collect the.
No, don't do like that. Once you have heard it,
Anything down.
20 matter,
But
Lordship.
the tribunal is-
No, my lord, after my marriage,
no, this is, this we can't
We are not
allow.
concerned with after your marriage, before the marriage. After your
before,
marriage,
before my marriage, only one brother name in enlisted
No,
in the
you must
voter
do
list.
your homework before you start arguing. Once you start arguing, then there is no point giving you opportunity to add on
Before,
documents.
my lord, before 89, only one of my brother's name is enrolled in the voter list. That is Omar Kazi, 1977, 1970. And another brother, after my marriage,
In the parental family, you have not been able to connect. The only connection was that panchayat certificate that is gone.
and the position of Omar Kazi. Voter list of Omar Kazi.
Unless you connect, that doesn't help you. What Omar Kazi maybe is the son of Sagar Ali
Yes,
or
ma'am.
Sagar Ali Sheikh,
Yes,
but that doesn't make him you are the Sagar Ali Sheikh, your projected father. Santi. Santi. What is the last voter list of your father?
That is 1977.
That is the last voter list of your father.
I have enclosed.
No. Enclosed, we are definitely we are asking for something which is there on record. But then again, the tribunal is right. You are giving a deposition on 7th June 2017.
Yes,
You say your father expired 13, 14 years back. But that 13, 14 years back would make it 2000. There should have been some voter list existing till then, along with your father. Sorry, your father along with the family members. There's a disconnect. Take a break and come back. Ms. Verma, you have to address us.
Yes, Lord.
You are Mr. M. Shalim.
yes, my lord.
Can you show any other document which connects you to the projected father?
In this case, my
Any
my-
document on record?
not in the record, but some time is, my lord.
No, that can't be. If you have to take a German, please take it at the first blush. You can't. After
Right
we
now,
have heard, we can't adjourn the matter like that.
right now, no documents are with me, my lord. Only that,
Lordship will have to decide whatever is before Lordship law. Cannot bring in new documents to improve his case now.
Correct.
but my lord. The authority,
Even the Gaon Buddha has been summoned. He has also deposed Lordship. And he has, if Lordship will look at the opinion at page 89, Lordship.
Gawra is DW3.
DW3, Khagen Khari, son of so-and-so, resident of so-and-so, serving as secretary Joramukhi Gaon Panchayat,
that
has
is,
stated that after receiving summons from this tribunal, he brought the relevant records in connection with this reference. Exhibit H is the linkage certificate issued by the then secretary so-and-so in favor of Sona Bhanu
So in the
Devi.
cross, it says it's for NRC purpose.
Yes, that is it, Lordship. That the only link document which he is relying on is that NRC certificate, and which is not admissible, Lordship. And it was issued for the purpose of NRC and does not know the OP personally. He has no other document to show the linkage with his father and brothers and sisters, Lordship. 10 brothers and sisters. Somebody's name ought to have been there with the parents, Lordship.
no, before, after 18, there may be some botalis with his other
What has
brother and
not been
sisters.
exhibited before the tribunal cannot
Yes, yes.
be taken up now, Lordship.
You should have done it because this is a 2020 matter. You should have done it earlier. Okay.
And references of much earlier lordship, this references of 2017.
No, notice.
Iron Chetty case was 2000.
17. Notice.
So they are very much in knowledge, it is in their
No.
knowledge that they have a reference pending lordship.
No.
Of
Only
2000.
2017 notice has been
It's
served.
okay, whatever be, but references of
2000 lordship.
2017 notice.
The inquiry was done in the year 2000 lordship. It was first registered in 2000, though the notice went in after 17 years.
but that's okay. Okay, we'll pass orders in chambers. What's the next? Next.
तुम्ही आता केसे नाही घेतले. तुम्ही कसं येते तुम्हाला को नाही केसे नाही. हे तू. म्हणजे
Item 8.
May I please your lordship? In this matter, we submitted WS, we submitted evidence in chief. After that, the learned counsel in the tribunal, without informing us, withdrew the wakalatnama. Now, my lords, kindly come to page 55. And hence,
55.
yeah, and hence the tribunal proceeded ex parte. Let's
55, yes.
May I read your lordship? I read from the second line. OP further stated that his name had appeared along with his mother, brother in the voter list in the year 1994, but his name and relation name was wrongly inserted in the said document.
You are reading which page?
Page 55, your lordship.
55, the first line is the voters list of the year
Yes,
19.
I am reading from second sentence.
Second line.
Yes, yes. OP further stated that his name has appeared along with his mother and brother in the voter list of the year 1994, but his name and his relation name was wrongly inserted in the same document. OP had pleaded that against his own sister, namely Sukuri Nesa's SP border Borpeta, and registered a case as an illegal migrant and referred to so-and-so. However, the learned tribunal so-and-so had passed in judgment so-and-so, while she was declared an Indian citizen by birth. OP had stated that in the voter list of the year 1997, his name was marked as the voter. No, your lordship, my own sister has been declared Indian, and in the written statement I mentioned it. Now, the tribunal acknowledged the exhibit, but give no reason of discarding this document. Now, let's kindly come to page 93. Is the judgment of my sister declaring her to be an Indian.
Now, how was the document exhibited?
Your
Your
lordship,
sister did not come to depose.
yes, your lordship.
She was a witness.
No, your lordship.
Then
Because your lordship, the council at the tribunal, without informing us, withdrew the wakalat.
no, I understand, but I would have loved it. You see, to produce a copy of the Tata Cellular judgment and then claim that I am giving the judgment of Tata Cellular. So therefore, I am one of the
It
lineage
applies to me
members
also.
of Tata Group. I can't become that.
Your lordship, may I submit on this regard, your lordship? A, we are relying on the same set of documents, and B, your lordship, there's a division bench judgment of
It's
this
not
honorable
given,
court, in which the division bench has said that
It's not
Uh,
a reasoned order.
if
No, your sister does not come and depose that you are her brother.
yes,
Therefore, it's not relevant.
Lordship will
You are
look at
claiming.
order passed by in 2002 for the sister. It's not even a reasoned order. Nothing has
No,
been
that's
discussed.
apart. Whether there is a reason or not, the state does not agree by that. But
Yes.
the question is that if the sister does not come and depose that she is your sister, merely by producing a certified copy of an order would not make you.
yes. So may I, your lordship, rely on a judgment?
Please.
कौन सा जजमेंट
Why do you think?
मेरे पास है
We are calling.
Yes, give the citation, please.
May I request, court master? I've
ये
submitted.
जजमेंट को कॉपी टू
judgment.
Okay.
उनको नहीं किया
মেল করেছেন আপনাকে
हाँ सर
আচ্ছা। हमको भेजो तो
Yes,
at page 16 your lords at para 16
page
para 16
para 16.
कौन सा साल का जजमेंट है
2021
20
1
WPC
एक सेकंड application number 312
लिखा हुआ है क्या?
yeah it's yeah mentioned. May I read from para 16 at page 9? When two conflicting opinions are given by the tribunal on the claim of legacy traceable to the same person, and if these opinions relate to the blood relation as brother or sister, the one favorable to either of the sibling can be applied to the other. The fact that one of the sibling has been successful to prove that he is Indian and not a foreigner thus clearly indicate that there are sufficient cogent materials to support such a claim made by the other sibling. Failure on the part of the other sibling to convince the tribunal could be because of certain shortcomings in the nature of evidence adduced, which may be attributable to muster the evidence sufficient attributable to inability to muster sufficient evidence material evidence which may, etc. Standard of proof in such proceeding being preponderance of probability, it can be certainly said that if one of the sibling blood relation has been able to prove his case that he is Indian, there cannot be any doubt that the other sibling will also be an Indian, even if other sibling does not adduce any evidence except to prove that he is the brother or is otherwise. It would be against the law of nature and common sense that the sibling will have different citizenship status unless relinquished by any of them. Thus, the beneficial view must prevail in such a situation as arising hereunder. Now, your lordship, in this judgment later on, from para 22, honorable the division bench passes catena of directions for the on to the state so that there cannot be there cannot be an arbitrariness while forming a judgment, because there were judgments that were coming up where brothers were one brother has been declared Indian, the other has been declared foreigner. So the moment we take a plea that my sister has been declared Indian by so and so tribunal, it was the incumbent of upon the tribunal to verify the claim. They had enough power in the foreigners tribunal order to summon. And also your lordship, we are only we were the learned counsel at the tribunal withdrew the wakalatnama without informing us. If your lordship,
What steps have you taken against the council?
your lordship,
What steps have you taken against the council for withdrawal of wakalatnama
we-
without intimation?
with your lordship, that's one of our prayer that we are here. So we are too poor. The council,
No, what is there
petitioners-
to be poor and rich about making a complaint against the council who goes against your instructions? You know the forum.
Yes, your lordship.
Then what steps have you
I'll
taken?
certainly, I'll certainly.
That is, we are not advising you to do
I'll
anything. We are
certainly-
trying to see your bona fides. That is your ground that the council was not there, therefore you could not place the order. Or you could not take all steps to argue the matter. Now, what steps have you taken against such a council?
Your lordship,
Nothing. How do we take that statement on face value?
otherwise, your lordship, in such a good case, why would I want myself to be declared foreigner? Why would I not
When was this order passed?
in 2021? Sorry, your
Where is the opinion of your
25
brother?
Huh?
Where is the opinion of your projected brother?
projected sister 93, your lordship,
Lordship, opinion was passed in 2020.
2020. My opponents.
This was in 2014.
Yes, your lordship. We submitted this order copied in the written statement.
It was there.
Yes.
Have you annexed the written statement?
No, it must be there in there.
Lordship, in the records, Lordship can find the written statement. It's not annexed to the petition.
Hmm?
Records are there, Lordship.
Yes, it's available.
Where in the written statement you have mentioned, page number?
I don't have the written statement, Your Lordship, but
Lordship, can we
In-
go
in
through the records? We'll assist Lordship.
in evidence of chief at page 65, is there in the writ? It is exhibited as E. Even the tribunal order mentions it. That we have pleaded. My father was also declared Indian. Your Lordship.
By which order?
That is at page 91.
Lordship, it's a very vague order, and the evidence adduced by the OP, what evidence was adduced, Lordship, and what evidence, no findings of the evidence. And how it has been proved, that is also not there. In one paragraph, he declared the father to be an Indian Lordship without discussing
See, the
anything.
authorities are happy with this order. They're not taking steps against the presiding officer of the then tribunal.
Because father's name was appeared in 1971.
Personally, I would have loved it. I would just have to say the case of the petitioner is in the writ petition. Response of the respondents are in the affidavit in opposition.
Yes.
I allow the writ petition. Considered. Three things I have to write.
Yes.
Heard, considered, an opinion.
Opinion. One of the most shortest opinions to declare them Indians Lordship. Hardly 4 lines.
No, the state could have filed an appeal. State is aware of this opinion. State has not filed an appeal. So therefore,
Yeah, we are at fault here, Lordship.
once an opinion is rendered, the government is bound by it.
Lordship, whether the LCRs are there of the father and the sister also, it would be interesting to see if all the written statements carry the same names, Lordship. The father also said that he is my son, she is my daughter, and the sister also said he's my brother and he's my father.
What is the name of your brother?
Brother.
The brother is Makbar Ali, the petitioner before Lordship.
No, the brother whose opinion was
Brother.
there.
Sister.
Sister, yes. What is the name?
Sukuri Nessa.
Shukuri Nessa. I think LCR was called for all 3 of them. I remember this matter.
Just a moment.
If not, Lordship will call for the LCR of all the 3 cases, Lordship. We would like to even peruse them.
Lordship,
They are not under challenge. Those orders are not under challenge.
Lordship, even when they're not under challenge and they're relying on it, court always asks for the LCR of all the cases which they rely on. It will become evident whether the father had, in his written statement, put up the names of his children, or the sister had put up the names of his
It's
child.
for the tribunal to decide.
It's for the tribunal.
Why
We
should
can't
we
enter
embed
into
But
that.
this was both were before the tribunal.
No,
the
because in the
fathers
written
and
statement, we
sisters,
find that he has given a statement in paragraph 12. Yes, yes. Mhm.
Everything,
Written statement. Is it tribunal?
It's finalization, so. Yes.
Because you have to call it an argument, but it's not clear as if parents would- So, no, people are gonna get away. Yeah, it would be different.
W such Russian, he said that they have annexed the orders.
I thought this was- these are considered problems. Ms. Verma, we allow him to go on bail,
Yes,
the Makbar Ali first.
Lordship, it will require further hearing this matter. And
That's
in
why
the
we are,
case, my lordship may kindly call for the records of the father and the daughter also.
no, here you see.
Lordship, for proper adjudication, my prayer is.
We are not adjudicating. Because this is a case where the proceedee did not appear before the tribunal for cross-examination. And therefore, when there is an opinion of the tribunal, we intend to send it back to the tribunal to give an opportunity to appear in and face the cross-examination.
Yes,
And if required, the tribunal will call for the records and do whatever it wants. Because the High Court, while calling for the record, cannot give a finding of fact in a writ petition. Because to call that record to examine, you see, we are also asking for another document to be brought on record. Normally, we are not doing it. Because we are not giving that same opportunity to the petitioners to add on the documents and to.
Fair enough, lordship.
Permit him to go on bail first, and then on the next date we'll pass on for that. After hearing you.
Yes, lordship.
Had Mr. KW Amanda counsel for the petitioner. Yes, A. Verma, standing also for the FT, Mr. R.K. Talukdar and government advocate, and Mr. A.I. Ali, standing also for the Election Commission of India. Next, pursuant to order dated 18/7/2022 and 9/8/2022, the records from the Foreigners Tribunal is received. Next paragraph, no. It appears that the matter would require some consideration. Next paragraph, accordingly. In the meantime, the court is inclined to allow the petitioner to appear before the Superintendent of Police, Border,
Borpeta.
Bolpeta.
Bopeta, Below 5,000. The within a period of 10 days from today. First of on the next date, the counsel to the petitioner shall inform the court as to whether the petitioner has taken bail or not. Next para, list. After 2 weeks on a date to be fixed by the office.
Much obliged.
Item 9.
Yes, Mr. Hassan.
Next, the Lordship. Lordship, in this case, Lordship petitioner declared for the post of 71. Lordship petitioner submitted the brutalist of 1965 father, named Jubbar Ali, 1970, 1975.
What is your written statement, Mr. Hassan?
WS, my lord. Page 55, my lord.
57,
55.
55. To prove linkage certificate, did the Gawbura appear?
No, linkage certificate Gabura has not appeared, my lord. I have a link with my father. There is a Jababundi copy. My father name, my brother name, my name is there. Then after my lord, one link certificate, next of kin certificate. After death of my father, we obtained the next of kin certificate from the DCO office. That is the link, my lord.
Where is the land document?
Jababundi, my lord, page 42.
42.
Yes, my lord.
Yes,
How-
page 44. Where is the entry?
My lord.
The original one is at page 44, which is the entry by which your name is entered.
My lord, and my lord, name is there. Serial number 31. Is 45.
Serial number 31.
Yes, my lord.
No, what is the in the remark column? Where is the remark?
44. Page 44, Lordship.
Very small. So, hold on, brother.
How old is your petitioner? Your affidavit to complete to DI 90.
In the written statement, he has stated about land.
Yes, my lord. Let me state it, my lord.
$73 bond. Remember, 24 method. 73, 2000, 21.
9.
51. Application.
Page 45. Criticism. 18. Hmm? Okay. As long as we are giving him bail, the petitioner. The written statement is exhaustive. F.A. Hassan, counsel for the petitioner. Respondents, Ms. A. Verma, Mr. R.K. Talukdar and Mr. A.I. Ali. Pursuant to the order dated 28/6/2024. The records of the tribunal is received. This one. It appears the matter would require some consideration. Therefore, the court is inclined to grant bail to the to direct the petition to appear before the Superintendent of Police Borpeta. Yes, my lord. The intent is and take bail. Same terms. Next paragraph. On the next date, the learned counsel for the petitioner shall inform the court as to whether the petitioner Manwara Begum has appeared before the Superintendent of Police Borpeta and taken bail. Next one, list after 2 weeks on a date to be fixed by the office. In fact, I think just. No, you see, you give a date 23rd October. Like making it after Puja now. For hearing. August. No, in fact, we are not admitted it. Let them go through the records. Only notice was issued, we are not admitted it.
Will be for admission hearing.
Admission.
Item 10 for orders.
May I please, your lordship, I pray for timing of this matter, your lordship, if possible, your lordship. She's on legs in another.
No time being today. It can be time being today.
You have seen the cause list. Timing can only be half a minute or 1 minute. Yes, what is the ground for review? You are aware what is the ground of review?
Yes, your lordship, it relates to the shifting, your lordship. The earlier writ petition was dismissed, your lordship, that is in page 47, your lordship. On 48, page number 48, your lordship, of the review petition, your lordship, para 3. On a query being put to the learned counsel for the petitioner as to whether any further material is available to show that the petitioner had migrated from village Amguri part 1 of Abhaipuri police station to any of the 3 villages namely Nashatra, Baghekheti and Pakakata. It is stated that no further material is available on record to establish the same. But Lordship, there is an affidavit was filed, Your
See,
Lordship.
we'll give you time for different reason.
Because they have
The review grounds, another set of council, not only select, another electricity.
change of lawyers and new branches.
You note down will, but next time you'll have to make the argument. We are not dismissing it because you are standing before us and therefore we want that you would make your submissions, correct? You'll not hear your senior on the next date.
Lordship.
You'll notice addition. 1997, note it down, 1997, 9 SCC, 736. Correct.
Lordship.
Be prepared, you go through it. The point which is involved, you will, once you open it, you will find it. And you address us on the next date.
Lordship.
Correct.
Lordship.
We are fixing it on 6th of September. You will get quite some time.
6th of September.
Correct.
Lordship.
Okay.
Oblige, Your Lordship.
Just wait for the order to be passed. Don't be so fast. Miss
FN Jaman.
FN Zaman, counsel for the petitioner. Ms. Verma, Sir Ankit Alugdar. Yeah, Ali. Yes, on the prayer made by the learned counsel for the petitioner, the matter stands adjourned today. List on 6/9/2024. Correct.
Oblige.
But we'll hear you. Remember, be prepared.
Lordship.
Item 11.
I pray the Lordship. What is the
Yes, review petition
thank you, order is at page 56, Lordship.
56.
56, Lordship.
Just
Lordship, the
a
petition.
moment, just a moment. Which page?
Lordship, the tribunal's order is at page 56, Lordship.
56, yes.
56.
Yes,
Lordship, the petitioners, they were declared as foreigner, Lordship. Thereafter, they
yes.
approached this Honorable High Court, and the Honorable High Court's order is at page 66, Lordship. And the operative part is at page 68, Lordship.
Yes,
Lordship, may I read?
yes.
On perusal of the averment made in the writ petition, it is seen that there is no explanation for this delay of more than 5 years in approaching the High Court, the writ court. Only a vague statement has been made. In paragraph 18, that petitioners being poor and illiterate persons, it took time to obtain relevant copies of the voter list. Evidence tendered before the tribunal and order of the tribunal. We are afraid such averments are wholly inadequate and does not explain the delay of more than 5 years in instituting the challenge by approaching the court. As is evident, there is considerable delay and laches on part of the petitioners. In approaching the court, such inordinate delay has remained unexplained. A person who has been declared to be a foreigner by a duly constituted tribunal is expected to show due diligence and alertness in approaching the writ court to question the finding of the tribunal. But such diligence and alertness is totally absent in the case of the petitioners. Lordship, without going into the merit, the writ petition was dismissed, Lordship, on the ground of delay. Thereafter, we approached the Honorable Supreme Court, Your Lordship, and the order is at page 70.
Which order you are relying on?
Lordship,
Or
Lordship,
your relative who was declared to be an Indian?
Lordship.
Where is that order?
Lordship, that order is at page 59, Lordship. That is a typed copy, Lordship.
Who is the person?
Safayat Ali, Lordship. He is the brother of the Habibullah. His name appeared along with Habibullah in the Jamabandi copy, Lordship, page 22.
Habibullah, what is the name of the father?
Habibullah alias Habibul. And his name appeared in the Jamabandi copy, Lordship, page 22. Habibur Rahman, serial number 5, Safayat Ali.
Who is the earlier proceedee, Habibullah? Who is he?
Okay. Father of petitioner's number 1, 2,
Okay.
1 and 3, Lordship, and
Mr.
husband of
Sharma,
the
you go through the records and then tell us. We'll take it up next. Either on Monday or
Lordship.
Friday. Friday, I think. Monday. Monday. Okay. The positive time could not be for today. List on 9/9/2024. This all sides are represented.
No.
Oh, acha. It is sixth.
Lordship, can it be on 5th, Lordship?
Fifth, we are reserving for few hearing matters.
Lordship, then on 10th, Lordship.
Then it will go to 11.
11th.
Lordship.
Okay, 11th. 11th.
May I please do Lordship, mention Lordship. In item number 16, Lordship, it has been listed by order, Lordship. There is some urgency, Lordship. That's why I'm praying for it may be listed on Monday, Lordship.
16.
16, Lordship.
15,
Supplemental
1/5.
list, Lordship.
Okay, make it Monday. 15.
On Monday, Lordship.
16 is for orders.
Yes,
Why it has come?
Lordship,
What is the I for?
I have for Lordship, for seeking extension of time to appear on before the rounded.
What is the reason for not appearing?
Lordship, what happened, Lordship, the client has lost the communication, Lordship. Client has lost the communication with the engaged counsel, Lordship, me, Lordship. She had a phone that was malfunction and not working. That's why he would not contact with me, Lordship. I have also tried, but since the phone number was malfunction, Lordship, that's
This ground, does it appear good to you?
that's the on true fair loss.
It doesn't appear to be good to us. Okay, Monday.
Loss.
May I please, Lordship? Lord, regarding item number 14, there is an I for bail. Madam. May I pray for listing the matter on Tuesday, madam, 3/9.
Okay, Tuesday.
Obliged.
May I please? Item number 12, my lord. My lord, this matter has listed for 5 times, my lord, but not listing. May I pay, my lord, for listing on Tuesday, my lord.
For hearing. Orders.
Orders, my lord.
Orders will come on, you have it on Monday, we want.
Monday.
Monday.
Bless you.
May it be please, your Lordship. Lordship, I beg to mention item number 12, Lordship.
Item number?
12, Lordship. In this case, we want to file implement petition, Lordship. 1 week time may be allowed to file our implement petition, Lordship.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. Matter stands adjourned today to enable the petitioner to file an impleading application. List along with the list as and when the interlocutory application is filed.
Lordship, similar brain, item number 3, your Lordships. We are
3.
supposed to implement, yes, Lordships, implement the contemporary, your Lordship. Item number 3.
3.
Monica, sir.
Same order.
Implement probably. Yes. Deeply apply, Lordships.
All orders, daily list item 1.
Yes, please, Your Lordship. This petition is filed and non-compliance of the order dated 10/4/2018, Lordship. Page 8 and 7.
Order dated 3/5/2024.
5.
Implement of the new.
Yes.
That has not been done.
No, but what about the status of the compliance by respondent number 1, Mr. Chisti, for whom we are appearing?
Earlier, Lachana 1 has and delegate time clear already processed and the matter has been.
Because the order is that you will be bringing on record the compliance report. Your affidavit is also not here.
My latest instruction from the present secretary Lordship, who I am not representing, but that matter has been submitted to finance on 23/7/24 for necessary concurrence and for sanction. As soon as the finance give the sanction notice, it will be given. That is the instruction that I received from the present secretary.
But you'll have to file an affidavit. It's a contempt matter. Oral submissions will bind you.
Yes.
You will also be.
Earlier, the commissioner whom I represent, he retired 4 years back. So he is not, that's why you are supposed to include the new secretary. So that I can file the affidavit on behalf of the new secretary.
But who's respondent number 1?
Earlier it was freedom secretary.
SN Chaudhary.
Yes, I'm actually sorry. I'll file it within a week.
Huh?
I'll file it within a week.
Within a
I'm
week.
really sorry. I apologize. I'm sorry. By Monday, I'll file.
Okay. Counsel for the petitioner and respondent number 1 are present. It is seen that the interlocutory application to implead the present applicants has not been filed despite order dated 3/5/2024. Next paragraph. Mr. SMT Chisti, learned counsel for respondent number 1, prays for his method 1 week's time to file on record the compliance report as mentioned in the order dated 3/5/2024. Next paragraph. List after a week.
Obliged.
Item 2.
Yes.
My lord, this was because the salary, the petitioner Prayer is the payment for payment the salary of the period. He served already.
But you see, this contempt petition, I
Yes.
don't know why it is pending like this. You see the cost title at paragraph 2. Page 2, sorry, of your contempt petition,
Contempt
page 2.
yes, my lord.
No, contemptor is Director of Secondary Education.
Yes.
It's not by name. Contempt by
Uh,
name is not there.
Director, my lord, the order has discussed in the last page that the salary that he worked for period for the he worked, that payment should be was directed to pay.
No, but
pay,
how do we
not
proceed?
for punishment. Any other punishment question does not arise. But the period he worked, the salary.
No, Mr. Malakas, the problem is that in a contempt jurisdiction, we don't have a we don't have jurisdiction to issue directions.
Yes.
We can merely punish people, but we can't issue directions.
Yes.
You know the law.
No, my lord, it is page 13 in the
No, we understand, but how do we enforce the order? You say that, you see, it's by office.
The nature of the order is like that, my lord. At page 13 in the contempt petition, there is
Yes.
a indication is there. Page 13. The period for the salary for the period he served. That's like order is that like 13 pages. The bill has been made according to in deadline. 6 months salary, only that will be the indication. And my lord, inspector of schools has accordingly in that line has made the bill which has been given to the director for payment.
Mr. Malakar, we only need one answer. How do we enforce the order?
So like in that line,
Against an office, we can't do anything. We can't issue a direction. How do we compel the director of secondary education to comply with the order? We can't arrest him. We can't arrest the office.
the direction has been given. This director, secondary education, has in that line has directed the inspector of schools and for making the payment bill for payment, and he has given the
Mr.
bill.
Malakar, we are again asking you the same question.
Yes.
In a contempt, how do you expect the court to proceed when a party is not implemented by name?
My name is not has been given, but the director director to changing time to time. That is why it was like that. The responsibility.
How do you enforce? How do you enforce? You tell us. You see, you have more experience than the years of
No, my lord,
experience I have.
No,
You have more experience than me. Just tell us, how do we enforce the order? In contempt, we don't have power to issue directions.
well, the remaining salary that is pending for payment, that is the target given in that line.
You tell us, how can we help you?
Direction already given already, the director to for payment of the salary, pending salary.
We can't do.
From the
unless
court
you-
also.
Unless you take appropriate steps, unless you do what is wanted, you can't do anything.
The courts are also in that line.
On the next date, the Mr. R.K. Malakal and counsel for the petitioner shall make his submissions as to how the order of the court can be implemented when the respondent is the office of the Director of Secondary Education Assam. List after 2 weeks. You please apprise us of the law. How do we proceed against the director? How to enforce the order? Listing it after 2 weeks, be prepared on that day. How can we proceed against the office of the director by name without person being named?
Item 4.
Well, already letter has been given already from the circle office. Accordingly, bill has been given by only for to pass the bill like this.
You tell us after next week. We're fixing it after 2 weeks. Yes, item 4.
My lord, in this case, my lord, I have to collect some instructions.
Here you have already issued the speaking order notice.
Okay, if order is passed,
And certificate for doing also. Director of the respondent operating will examine that claim of petitioner office. As per the new act. So it was examined and it was actually found that on the claim of petitioner cannot be considered as per the act of 2017 lawsuits.
Okay. Mr. M.G. Barber and the counsel for the petitioner. Waits for some time to obtain instructions. Next para. Next, probably Mr. SMT Chisti. You are appearing for whom?
Yeah, I'm getting counter with each property, because they're paying for additional group, because he is requested me to appeal also.
Okay, when council appearing on behalf of Ms. P. Chakravarti, current council for respond number 2. Submitted that earlier a copy of an order dated 4/9/2021 was placed, issued by the Director of Secondary Education Assam, was placed before this court, and by order dated 30/9/2021, it was submitted before the court on behalf of respondent number 2 that the said order dated 4/9/2021 of the director requires modification for providing a reason as to why the claim of the petitioner should be rejected. Accordingly, copy of order dated 29/9/2021 issued by the Director of Secondary Education Assam is produced before the court. You're giving him a copy?
That's provided.
Yeah. And copy thereof is provided to Mr. M.J. Barua, counsel for the petitioner. Next, please. It is submitted on behalf of respondent number 2 that the claim of the petitioner was rejected. In case of the claim of the petitioner for provincialization of service cannot be considered for cannot be considered. Next paragraph. Be that as it may, on the prayer made by learned counsel for the petitioner, matter stands adjourned today, list after 2 weeks.
Item 5,
I think it would be better you file an affidavit, otherwise these things become very difficult for us to. It took us so much of time to go through it. And the respondent, team shall file an affidavit to bring on record the stand of the respondents. It shall be done within 2 weeks. Okay. List of 2 weeks. Yes, sir. This is
item 5.
item 5.
May Mr. Lordship. Lordship, as per direction made by this Honorable Court Lordship, case 11 Lordship, there are 7. The inspector of school has passed a dismissing order Lordship, allowing the petitioner to receive the salary, but till date the salary has not been paid. Lordship.
I think you have to do it in full.
Yes, Lordship.
I don't think respondent number 1 is in office.
Direction only to the respondent 4, and this is the speaking order he has already issued.
Huh?
The speaking order, direction was para 7 was only to the respondent 4, inspector of school Walpara. To dispose of the representation of the petitioner. So he has accordingly disposed of the representation, holding that he is entitled for a salary.
Second prep from the bottom. Lordship.
Content, the director has been complied.
Just a moment, where is the order first? According to the petition disposed of.
Page 11, para 7.
I've seen that. You can examine the claim of the petition, dispose of the petition. File an affidavit and bring on record, because in contempt matters without a affidavit, I find it very difficult to.
Only thing is that it also petition from.
No, because Mr. Khetri,
The inspector of school that he was made party, independence, he is no longer holding the post. The issue is subsequent inspector of school lawsuit, Sadullah Khan. Now he is also has been transferred lawsuit. That is why lawsuit, there should have increased the present income. This is issued by one Sadullah Khan, and when the contract petition was filed, one independence was made a party. He has transferred, now Sadullah Khan has also been transferred.
oh. You given a copy to him?
I have.
Okay.
The compliance lawsuits that has been done.
Only Lordship,
He
the
did not
salary
pay
has not been
salary,
paid.
he
Otherwise,
paid-
Lordship, the speaking order has been passed, Lordship. As per direction.
The contempt can be closed. We can file a petition for.
Yes.
Not getting any salary.
Technically, it is right. The presentation has been disposed of.
Yes.
So this close.
Yes.
Here, S. Alam.
Yes.
Heard Mr. S. Alam, learned counsel for the petitioner. Next one. Mr. SMT Chisti, learned counsel for the respondent number 3. Has submitted that all 3 respondents have superannuated Mr. However, he has received instructions.
That's earlier, transfer, not superannuation transfer.
So 1 and 2, they are
Oh, 1 and 2, yes. One has been retired lordship, and 2 is not retired.
1 and 2 is retired.
One to retired.
1 and 2 is retired, and the respondent 3 has been since transferred. Full stop. It is submitted that the previous incumbent to the office of the Inspector of Schools, Gwalpara District Circle, namely Mr.
Yes, it's a try one with S.
F. Khan. Mr. F. Khan.
S. Lordship Sadullah.
Huh?
Sadullah. S.
S. Sadullah. Okay, S. Sadullah has provided to him a speaking order dated 30/9/2021 by the then Inspector of Schools, Gwalpara District Circle, Gwalpara, that by which the petitioner was held to be entitled to receive his salary with effect from 1/7/1994 till termination from his service. Full stop. Next paragraph. The learned counsel for the petitioner has submitted that although the speaking order was passed on 30/9/2021, but till date, as per instructions received, the petitioner has not received his dues. Next paragraph. Be that as it may, as the directions in the order of the court dated 9/12/2019, passed in WPC 725 of 2017, was limited to direction upon the respondent, direction upon the Inspector of Schools, Gwalpara District Circle, to pass a speaking order for release of salary. For the service rendered by him till he was terminated from service. Court is of the considered opinion that by passing of this speaking order, the herein before referred order dated 9/12/2019 passed in WBC 725 of 2017 has been complied with. Next paragraph. Insofar as the submission of the learned counsel for the petitioner is concerned, that the petitioner has not received his salary, it will be open to the petitioner to take such steps as he may be so advised. Next paragraph. The photocopy of the order dated, speaking order dated 30/9/2021 by the Inspector of Schools, GDC, Golaghat. GDCs में Golaghat, Gwalpara District Circle, Gwalpara, is produced by the learned by the Learned Counsel for Respondent number 3 is made a part of record.
Yes.
This contempt petition stands closed. Item 6.
Item 6.
Mr. Bhuya, this is your matter. Item 6.
No, he's everyone. Here it is everyone.
No. This is Mr. Bhuya's matter. You just go through it.
My name has been wrongly shown here.
No, but we know how to read it right. That's why we are saying.
I am
we're
extremely
calling you.
sorry, Miller.
It will deha diyo.
My lord, perhaps this has been a petition to us. Lord, I am sorry, actually.
It's okay. Obviously, you would not know A.B. Chaudhary.
My lord.
Sorry, A.B. Bhuya, but still go through the records.
My lord,
Take
I have
after
to-
some time and go through that.
Item 7.
May I please, your lordship?
Yes.
Lordship, kindly see the honorable court lordship, order lordship, page number 13 lordship, and relevant portion lordship, page number 31.
96-24, they are supposed to take page steps.
Yes, I have taken lordship.
96-24, may use the order.
I have taken lordship, step lordship, 26/2024 lordship.
Counsel for the petitioner. And Mr. SMT Chisti, the counsel for respondent number 1 is are present. Next, brother. It is noted that as per order dated 23/2024, respondent numbers 4, 5, and 6 have been impleted, and notices on them were issued. No, it was impleted, and the amended cost title is made a part of record. Stop. It is also seen that notices were issued on the newly implemented respondent numbers 4, 5, and 6 by registered post on the memo dated 24/6/2024. Full stop. Next paragraph, as per order dated, as per office note dated 28/8/2024, comma, AD card in respect of respondent number 6, namely Tridip Roy, is returned with the signature of one S. Ramita, PRAMITA, Sinha, SINGHA. Full stop. The notices is found to be issued on the correct postal address, and as AD card has been returned, notice on respondent number 6 is accepted to be duly served. As per postal track consignment details for respondent number 4 and 5, which is available on record. The notice appears to have been duly served on respondent number 4, namely Narayan Poor, ACS, and respondent number 5, Mamta Hojai. Full stop. Next, none appears on call for the newly impleted respondent numbers 4, 5, and 6. Full stop. Accordingly, the registry shall issue a warrant of arrest.
By Monday, I can bring the team and I can quickly, receive that. I take responsibility for and five.
For 4, 5, and 6.
6 I cannot locate because it is from district.
Then we issue a warrant on the issue number 6.
Yes, then
Let
I take responsibility.
Let a billable warrant of arrest be issued on respondent number 6 to compare his appearance before this court, directing him to appear before the court on or before, on 16/9/2024. Non-billable warrant of arrest for a sum would be 10,000. Most of the billable, non-billable warrant of arrest be served through the officer in charge of Hailakandi Police Station. Most of the registered to take appropriate steps. If required to be routed through the Chief Judicial Magistrate, Hailakandi. Then we are giving some more time.
Yes.
Make it 23 September. Next problem. The Mr. SMC received on counsel appearing for respondent number 1. Submitted that he has instructions to appear for respondent numbers 4 and 5. And he would be filing his Vakaratma within a week.
By Monday,
I'm giving a week's time.
week's time, yes.
Within a week. Full stop. List on 23/9/2024 for appearance of respondent number 6. And for response by respondent numbers 4 and 5. Next paragraph. The court is inclined to record that you make it for personal appearance for appearance of respondent numbers 4, 5, and 6. That's only that much. Appearance of respondent numbers 4, 5, and 6. Yes. Unless you file an affidavit and ask for exemption, you are not doing it. But the content people are not taking very seriously. 16 no, 20, 23 koi lo.
So in case, if you do not file affidavit notice.
We are not saying anything. You file will give you exemption under the contempt rules. Under the contempt rules, let's say prerogative of the court.
Yes.
So they receive what you call ID cards, they don't appear. Why we should show clemency? No, but once they receive notice, why clemency? They don't appear voluntarily. You have appeared out of your personal effort. No, not that. You see, in a contempt, it's not required. In a contempt, Mr. Chisti, assistance of the lawyer is not required. That is between the contender and the court. So therefore, that statement may not be acceptable. Okay, item number.
Time being item 6.
My lord, I have verified the order, my lord. My lord, this order has been complied with by passing and speaking order, my lord.
Okay.
Yes, my lord, and that is subsequently challenged, my lord.
Okay.
My lord. So
Okay.
my lord can close this
We can
petition.
close this matter.
My lord.
Okay. No. But Mr. A.R. Bhuiyan, learned counsel for the petitioner, was submitted upon instructions that in the meantime, a speaking order has been passed by the respondent authorities pursuant to order dated 27/1/2020, passed by this court in WPC 479 of 2020. Next, it is further submitted that as the order was adverse to the interest of the petitioner, the said order has already been assailed before this court. Full stop. Next, Mr. SMT Chisti, learned counsel for the respondents, is present. Next, in view of the compliance of the order of the court, this contempt petition stands closed.
Obliged.
Item 8.
May your lordship be pleased. Learned senior counsel has paid for time for filing a pleader notice for 2 weeks.
For filing?
For filing pleader's notice for 2 weeks. Yes.
But for filing any petition, they want to send a pleader notice past.
No, I understand, but I've got it. I just, who's appearing for whom I just take a note. You were appearing for, you are appearing in the matter now.
For a responder 1 or 3, I'm appearing for the earlier. second.
1 and 2 also then?
Yes. Two.
Okay.
They will retired.
Your name?
MM Das for RC Saikia.
Yes. Miss MM Das, learned counsel appearing on behalf of the counsel for the petitioner on record, and she plays for some time to take appropriate steps. Next one. Mr. SMT Chisti, appearing for the respondent numbers 1 and 2, had submitted that both the respondents are no longer holding the respective offices. This number 1 is retired or is still in service? One retired. Okay. And that as both of them have superannuation from service. Next one. Next one, be the resignee on the prayer made by the learned counsel for the petition. The matter stands adjourned today. List after
2 weeks.
2 weeks. Nine.
Item 9.
May I please, your lordship? My lord, both the incumbent and the has superannuated, my lord, and perhaps, my lord, the order which we are alleging that has not been complied with. My lord, I have received not confirmed instruction that it has been complied with, my lord. My respected friend may can also obtain instruction, my lord. If it is complied, my lord, then I think it can be closed on next week, my lord. Any date fixed by my lordship, my lord. Otherwise,
In fact, Mr. Gogoi.
smart.
Oh, yeah, oh, sorry. You were sitting there and I was, okay. Okay, please get instructions in the meantime. Okay. On the prayer made by Mr. A.R. Bhuyan and counsel for the petitioner, the matter stands adjourned to enable him to obtain instructions. To stop. Mr. K. Gogoi, appearing for respondent number 2, shall also obtain instructions that as to whether the order of the court has been complied with or not. Next para, list after 2 weeks.
Obliged.
Item 10.
May I please, your lordship? Discuss on order 3-5 May payroll.
Yes.
I'm appearing to this point, right? I've got an instruction from the department. My lord, being in the judicial department. Fine.
No, but what will the department do? What will the judicial department do? You see, the order is very clear. You have to dispose by directing the respondent authorities to verify the claim of the petitioner as to whether he is rendering service and he found to make payment. What will the judicial department do?
And it has been 4 years, madam.
Will they say that no, he is working, don't pay? We ask your officers to be personally present.
I'll do one thing, my lord, just give me at least 10 days time, I'm sure that we apply.
No, we'll give you, we'll give you more than time we are wanting. But we are listing it after 4 weeks. If the order is not complied, then personal appearance.
I'm appearing for respond 5 minutes.
Ah, yes.
The P. Chakravarti is no longer, my lord, counsel for the one of one. P. Chakravarti in the first list. He's no longer the counsel for the one number 1.
No, but respondent number 1 will still issue a direction. This, I think number 2 has expired.
I'm for 5 minutes.
So 1, 3, and 4. We'll have to issue notice for their personal appearance.
But last chance we given, I'll push up. So that the rank for this place.
Okay. Mr.
S. Dehinge. S. Dehinge.
S. Day.
Dehinge.
Counsel for the
S. Dehinge.
Oh, Dehinge. I'm sorry. Dehinge and counsel for the petitioner is present. Mr. A. Fukan Learned, counsel for respondent number 5. Has submitted that as per that he is informed that the petitioner number 1 has expired. Oh, sorry, has superannuated, and the petitioner number, sorry, respondent number 1 is superannuated, and respondent number, making a mistake. Number 1 has superannuated. Respondent number 1 has superannuated, and respondent number 2 has expired. Mr. SK Bhuyan has expired, I think. It is. Next paragraph. By producing a letter dated 29/8/2024, issued by the Joint Secretary to the Government of Assam, Department of School Education. It is submitted that he is instructed that the personal B department has given a suggestion to resubmit the matter for views regarding regularization of unauthorized absence period with the opinion of Judicial Department. Full stop. The Judicial Department has given its views, and the matter is again moved to the personal within bracket B department for the necessary views in the matter. And it is projected that on receipt of opinion from personal B department, necessary action will be taken. Next paragraph. The operative part of order dated 2011-2019 passed by this court in WPC 3895 of 2018 is quoted below. Paragraph 5, page 7. I'm putting up a flag. Full stop. From the contents of the order quoted above, the process projected to be undertaken by the communication dated 29/8/2024 issued by the Joint Secretary of the Government of Assam, Department of School Education, is not found to be in consonance with the order of the court. Full stop. Next paragraph. Having noted that the court has not exempted personal appearance of the respondents, we are inclined to issue notice on respondent number 5 to appear in person on April 11, 2025 failing which court may be compelled to initiate contempt proceedings. Full stop. In the event the order of the court is complied with, it will be open to the respondent of 5 to move an application for exemption from personal appearance. We are giving you 2 months time now.
No personal appearance.
Huh?
No personal appearance.
No, we have given conditional orders. My orders are always conditional. You do this or do that. You have options of 2. You came for 1, you are getting 2. The other one is free. You are influenced by large conglomerates. Giving something free. Okay. Item 11.
10.
This one, include date. 4th of November. 2024.
11.
Yes. Who's appearing for Bandana Datta? Anwaruddin Chaudhary.
Number 4.
Oh, excess amount has been refunded. Has been refunded. Okay. No, but what has happened to the other part of the order? You notionally fixing of paper, those things have been done? No, you don't have instructions. Unless you do this exercise, she will not get the petitioner. Who's the petitioner? Kamini Sonwal. Kanmai Sonwal. Something will be missing. You see, that part would be refunded. It is however made clear that the respondents would be entitled to notionally fix the pay of the petitioner with effect from 1/1/1987 by taking the correct pay scale, and a personal pensionary entitlement for future shall be worked out on the basis of such pay fixation. If you don't pay this, then you will be paying excess again.
The petitioner would be in a better position to clarify.
No, you see, the point is that one part of the contempt is over. You make the payment. But if you don't refix it, you will be again paying more. You see why recovery is made? Recovery is made because you are paying more. Now, if you don't rectify that, what happens? The state is losing money. No, it will be the education department who will be.
The final pension has been already issued. So the pension department will fix the.
Okay. So, Mr. Deori?
Refund aspect,
No, refund expense is okay.
in this aspect, your lordship may kindly give a short date.
No, because because you see again the same problem will arise. Here this.
Or your lordship will kindly allot 10 minutes.
No, we'll give you time. Don't worry about that. I'm not in hurry to dispose it off. But the problem is that unless you address this, contempt can be closed. But again, this problem will continue. It will remain.
If it has been addressed, that means the confirmation within 10 minutes.
Huh? We are giving you time. Don't worry, because I have to rise. We have to rise for the full court reference. We are giving you time, but the anxiety is that it should be brought to a close. None appears in call for the petitioner. Full stop. Heard Mr. B. Kaushik, learned counsel for the respondent number. You just say Mr. B. Kaushik, learned counsel, Mr. B. Deori, learned counsel, and Mr. H. Alia, learned counsel, appearing on for the respondents, for the concerned respondents. Next para. Mr. B. Kaushik, learned counsel, has produced a copy of order number capital EHA-23. Here, this order, huh? So dated 10/8/2021, issued by the Director, Elementary Education, Assam, to convey that sum of rupees 2,75,603 on account of excess drawal by the petitioner has been refunded in the concerned bank from where the petitioner is drawing his monthly pension. Next paragraph. Therefore, it appears that one part of the order has been complied with. One part of the order of the court has been complied with. Full stop. On a query of the court as to whether the correct fixation of pay of the petitioner with effect from 1/1/1987 has been worked out, comma, Mr. B. Deori, learned counsel for the respondent number. Mr. Deori, you are appearing for?
I for respondent number 5.
For counsel for respondent number 5. Prays for some time to obtain instructions. Full stop. Accordingly, matter stands adjourned today, list after 2 weeks. Please give him a copy of that order.
Since lordship, that is really also there because final the task should be done by both of us.
No, we are not discharging anyone. We are saying that one part of the order is complied with.
Both will take these.
Uh,
Otherwise, that's a liberty given to the respondent, not an election.
Because if we don't do this, state is losing money. That is the anxiety.
Item 13.
Target notice and appearing on the newly immediate respondent notice and I know tomorrow. Nothing can take it up next week any day. I have already.
Okay.
Yes, I have already informed you. Any day next week.
Okay. Mr. S.N. Tamulik, learned counsel for the petitioner, is present. Mr. S.M.T. Chisti, learned counsel, appears on behalf of the newly implemented respondent number 3. Number 2.
Number 2. The director elementary.
Okay.
Here contempt number 1 only.
And place for his. Huh?
Earlier, that's number 1
No, it's okay. No, I'm checking it because here the newly implemented respondent was respondent 2. But in the order, the notice is to be taken on respondent 3. That's why.
Lordship, there was a typographical mistake.
No, whatever we have, that's why I'm just checking it up. Because
Yes.
otherwise there will be, it will remain. Next one. And place for some time to file Vakalatama and to obtain instructions in the matter. Next one, it is also submitted that although notice was issued to the newly implemented respondent number 2, in the order dated 8/5/2024, typographical error has crept in and it is reflected as if notice was issued upon respondent number 3. Full stop. The court takes note of the said summation. Next part. On the here made by learned counsel for the respondent number 2, list on.
After 2 weeks, notice I have.
list on 209/2024. They're giving you more time, but see that the order is complied with. You're asking 1 week, we are giving you 3 weeks, but
14,
this is 2021 matter. SSC.
Yeah.
2021 matter.
Over one of the respondent. They have two service books. And Ranju Teka's service book was also taken by that.
That's okay. That's why we're giving some time.
Already
We're giving them some time, but let them bring it to our. Yes, Mr. Ali.
That is a loss. Lord, page 11, my lord. And direction part is page 12.
Okay, notice is served.
Loss appeared, my lord.
Okay. Yes, sole respondent. Yes, what has
Sole
happened?
res-
You have instructions?
As per the instruction which I received, the government has like written a letter, this is sending for preparing an appeal against this order. I'm trying to find out whether the appeal is already filed or.
No, he would have known it, Mr. Ali would have known it.
No, no.
Possibly not further because there is. delay.
Already 2 years.
I don't know whether it's filed or not, but I'm just trying to find out. whether it's filed.
No, let us say that you have filed it, but still if this new stay operating, you still have to comply with the order.
Yes.
So we come back to square one.
I don't know, give me 1 week time, I'll just find out.
Already 2 years gone, my lord. Oh.
You see the paragraph 5 of the order. What will the intercourt appeal, what would happen? Even if you file it, let us say we give it 1 week's time. Within 1 week, you file an appeal. Delays condone. It comes up before the bench. Against paragraph 5. What order do you expect? To bring the claims of the petitioner to its logical end. So you bring it to a logical end. What will I say?
Second part.
No, that's okay.
So the-
In doing so, they will do that. So that order has to be passed. The appellate order can't say that there's a representation or a claim pending. Don't do anything. You expect that order? No.
So the second part has been understood by the authorities as.
No, whatever they have understood, they are all well educated. Okay. Mr. Ali, counsel for the petitioner is present. Mr. B. Kaushik, learned counsel for the respondent. Please for a short adjournment. Prayer is allowed. List after a week. Let's pray for.
15,
Speaking order already.
You have it?
Yeah.
No.
Just now he served me, Lordship.
Kango, you have got it?
I have served a copy to her already.
Okay. You take instructions then?
Lordship,
Should not consider.
No.
yes, Lordship.
Okay. Mrs. Kanko, learned counsel for the petitioner is present. Mr. SMT Chisti, learned counsel appearing for newly implemented respondent numbers 4 and 5 has produced a copy of order dated 5/4/2023 passed by the Director of Secondary Education, Assam within bracket in charge, IC. Stop. Photocopy of the said order is retained on record. Stop. A copy of the said order has also been served on Mrs. Kango and counsel for the petitioner. Next paragraph, on the prayer made by learned counsel for the petitioner. List after 2 weeks so as to enable her to obtain instructions.
Lordship.
16.
Item number 16.
The same docket, I don't have the letter instruction. Let it come after a week, docket, I'll get it. I have already informed her. Similar case.
Both
docket.
come
Yes,
together, Lordship, Lordship.
If any order, I will pass a copy to her. Lordship. Both of them come together. Lordship.
Okay. Item 16. As Kanpur Council for the petitioner is present. Next para on the prayer made by Mr. S.M.T. Chisti, Land Council for respondent number 2. Matter stands adjourned today to enable him to obtain instructions list after 2 weeks. Along with
Both the marriages.
con case 581 of 2022.
Deeply obliged.
17.
Yes.
Malat, page 21,
Mr. Sharma, what is happening? This so thick. Why?
Malat, whether contempt will lies or not, all the connected matter have been tagged, my lord.
Whether contempt would lie or not.
Yes, my lord. And ultimately direction was issued to obtain instruction from the departmental authorities. Page 21, direction was issued to grant the benefit of provincialization of service under 2011 Act. And in the meantime, that act has been struck down.
But then the
But that judgment
contempt
is,
will not lie then.
my lord, judgment is still there, my lord. They have not filed any review petition.
So it's not required because you see, under the new act also your entitlement must come. Under the new law, the parameters have changed.
Therefore, they have to obtain instruction, my lord. Last occasion also. Let it come next
Because
week.
of change in law, Mr. Sharma, this is an order which becomes an unimplementable order.
My lord, in the meantime, my lord, the judgment was passed in the year 2019.
We understand, but for the delay,
Judgment.
the only question is that there is a delay.
Yes.
But now we are at a stage where the order is not compliable. So even the delay factor,
At the time, my lord, their names were forwarded under the 2011 Act.
Mr. Sharma, there are two things. Number one, in a contempt, you know our limitations to pass an order.
Yes.
Correct. That is one part. You see, there is a second issue also. In a contempt, unless we arrive at a finding that there has been a willful and deliberate violation, even for a purpose of delay, we can't pass any adverse orders.
Yes.
So now when the order by passage of time becomes uncompliable, today when we want to implement the order, it can't be implemented. So these are the two reasons which constitute good ground not to proceed with the matter.
B. Kaushik is directed to obtain instruction, my lord. He is supposed to obtain instruction.
No, let us say instructions come, which is even favorable to you. Let us say today, there is an instructions which is favorable to you. But can it be implemented?
They will say,
Unless you show that you meet the parameters of the new law.
let it come next week, my lord. Wait. No, speaking about my instruction, next week.
Action will never come. Because here, even if I would have been an officer, I would not have given an instruction because the officer will not be able to say that I will not comply with the order. And number two, with the new act coming in, unless he meets the parameter, he can't be appointed. So even if I step down to take that, wear that shoes, even I will not be able to comply with give you instructions. So this is an issue which only has a legal answer. Nobody will take the trouble of.
In fact, on this similar issues and the similar direction, because there is several review petition have been filed. Review has been filed before this. Only of this aspect of whether after the act has been struck down, or whether section 4 application.
Why is a review required? order of the court will be not incompliable because now the whatever you have to do is under the new act. You can't do you can't take an action of the old act.
Okay. There are mandamus directing for provincializing under the 2011 Act under Section 4, deeming it that there is a legal fiction where they under a deemed provincial, they have already accrued the right of provincialization. Whereas, my lord, in my respect to submission, my lord, in fact, in view of the recent constitutional bench judgment of the Supreme Court in the R.R. Kishore also, it has been very clarified. Once this act is struck down, my lord, there cannot be any enforceability.
Sir, why you file a review and call upon yourself at all? Okay. On the joint prayer made by Mr. N. Sharma, counsel for the petitioner, as well as Mr. B. Kaushik, learned counsel for the respondent number
Madam, respondent number 1.
1. The matter stands adjourned today. List after 2 weeks.
Yes. This one got 3.
3. Okay. These 3 matters, I think, will give a date. We'll take it on next because I have to rise. There's a full court reference. What is there? No, notice have been issued?
Notice issued. They have been.
I'll take instruction.
Both sides are represented. The prayer made by Mr. S.M.T. Chisti, counsel for the respondent. List after 2 weeks, so it's never able to obtain instructions. Item 19.
19.
Also, date may be fixed.
We're just giving a date because Puja is coming. We make a mention.
This today also this may by order. After 2 weeks, any day.
Date after 2 weeks. Date after 2 weeks. Item 19. Order complied with. But the counsel for the is not present. Mr. Mahanto. Yes. Complied with. Okay. Mr. D. Mahanto and counsel for the petitioner is present. Mr. B. Chaudhary and counsel appearing for the respondent has produced a copy of order dated 26/4/2024 issued by the secretary, BTC, by which it is projected that the order of the court has been complied with. The compliance of the order of the court is accepted by by the learned counsel for the petitioner. Accordingly, not accordingly, you say the copy of this order is retained on record. On satisfaction, this contempt petition stands closed. Item 20.
Item 20 is the await service report.
Service report is awaited. This is 20. How many respondents are there? 2. You are appearing. Okay. We give you 2 weeks time. 4 weeks time. Okay.
Let this matter be take along with the WPC matter 3227.
Why?
Sir, this is again the
Yes, madam. And that repetition is also pending. That's it.
No, then both things will not move. Let the repetition go. Contempt petition, let it be separate. Otherwise, your repetition will not move. Mr. A. Boro, counsel for the petitioner, is present. Mr. D. Nath, learned counsel, enters appearance for respondent number 1. And Ms. S.B. Gohai, learned counsel, appears for respondent number 2. And both prays for time to obtain instructions and to file affidavit in the matter. List after 4 weeks.
Well, let it 3 weeks, my lord. 4 weeks to
Let me file an affidavit.
Finally.
Oh, 4 weeks. No, do it. No. We give a date because then Puja vacation will be coming. 3/09/2024.
Well,
Okay.
obligatory.